National human rights institutions could play the role of a national preventive mechanism, but there's some questions which they need to ask before they do such or enter into such a new role. One is the issue of their staff. Do they have sufficient expertise in their staff? For example, to do proper prevention work, you need to have people who have some medical background. A lot of national human rights institutions normally have lawyers working with them, sometimes social scientists, etc., but they don't have multidisciplinary teams. There could be solutions to that. They can bring in experts, etc. But that's one issue, looking at staffing. The second issue is the issue of access to places of detention. National human rights institutions don't always have access, for example, to police places of detention or to military places of detention. In the optional protocol, the national preventive mechanism must have access to all places of detention. So this is a question, therefore, for national human rights institutions to ask whether their mandate can be adapted to the needs of the protocol. Another aspect would be the financial autonomy, whether they are sufficiently autonomous from the state, which is an important aspect of the protocol. Another important issue would be their capacity to do training work. This is an important requirement of the National Preventive Mechanism, to enter into, not just to be making recommendations, but to be entering into training programs, especially of detaining authorities, in particular the police. Do they have the staffing to do that? Are they interested to do that? A further aspect is, does the National Human Rights Institution have the capacity to make proposals of legislative reform? And then another important aspect for a National Human Rights Institution to consider is, normally they have investigatory mandates to investigate cases of abuse, including in prisons, etc. This can conflict with the preventive mandate, because the preventive mandate requires them to be entering into cooperation with detaining authorities. Now, if they are also at the same time investigating abuses and taking those persons to court, etc., there can be a clash of methodology, a clash of objectives, etc. In some cases, that might be possible to have very clearly defined units within an existing national human rights institution, where you wouldn't therefore have that clash of methodology, if I could put it that way, and that would be maybe a solution. Otherwise, it might be more sensible not to enter into the preventive work, but more to see how the National Human Rights Institution can support the work of a national preventive mechanism. So there are various issues to be considered, but clearly national human rights institutions have a serious potential to do the work of national preventive mechanisms, and that's why we always recommend that national human rights institutions be considered as potential national preventive mechanisms. But after they've answered these various questions, and whether they want to radically change the mandate of the National Human Rights Institution in order to accommodate the requirements of the National Preventive Mechanism.